SJC-13842, Commonwealth versus Scott M. Grimaldi.
Attorney Lynch.
May it please the court, Travis Lynch for the Commonwealth. The motion judge erred in suppressing the body-worn camera videos in this case. The fully uniformed state police troopers did not violate the wiretap statute when they used the body-worn cameras to record their interactions with the defendant at the sobriety checkpoint, where there was a sign posted at the outset of the checkpoint and where the cameras were openly displayed and had red lights illuminated on them when they were in operation. There's no secret recording here. And I would also say that under Gordon and Rainey, the legislature did not intend for the particular use of the recording devices in this case.
Show that the defendant saw the sign, or does it just have to be there?
Well, the fact that the effort was made to, it seems as though in cases like Jackson, it suggests that we have to show knowledge, but we don't seem to have actually have the defendant affirm that he actually saw the sign or anything.
Is there evidence that he did see it, though?
Well, he drove past it. I think that would allow circumstantially that he would have seen it.
But, I mean, wasn't he supposed to be impaired?
Well, then, I mean, he drove right past the sign. I mean, I don't think that means that it's a, I mean, again, it's not a secret if they're at least attempting to tell the defendant that there's a recording going on.
Does that go to secrecy or willfulness?
Well, I would say it would actually go to both, but because there is language in, say, Hyde that says, I'm sorry, that's about the device being displayed, the recording device being displayed. But I think I would say it actually goes to both. It goes both to secrecy and also to willfulness. But there's a sign. So clearly this is not willful in addition to it not being secret. So even if the defendant didn't know, the police certainly did not mean to secretly record the defendant. Either way, there's no violation of the wiretap statute.
You seem to concede the point that knowledge needs to be actual knowledge from a subjective standpoint?
No, I don't think so, because I don't think Jackson actually says it has to be subjective knowledge.
So if that's the case, how would we deal with the judge's factual findings?
If no subjective knowledge is required, then it doesn't really matter whether the defendant saw the sign at all, because they posted a sign and the cameras were openly displayed. But also I would note, among other things, in the video you can actually see the defendant look at Trooper Clark during the 9-step walk and turn from Cantwell's point of view. So he looks right at Trooper Clark while Trooper Clark is holding the camera up like this. So he must have seen the camera at that point, at least.
If he knew what it was.
Well, I'm not...
And that it was recording.
Well, I think that's reasonable to infer, given that I don't know what else, how else to describe it. They're obviously cameras.
But how would he know that it's audio recording?
Well, why I think it's just a reasonable inference, at least in 2024, that when you're interacting with the police and they're holding up a camera like this, that you're being recorded.
Well, counsel, you know the record a little bit better than I do because I didn't do that deep dive, but was there testimony that there's like a red light or something that appears when the camera is on? Was there actual testimony about that?
Yes, there's actually a passage in, I describe it in the brief, but I don't have the transcript, so it's right at hand. They actually describe how the cameras look when they're turned on. And also you can see in the videos, the red lights are on. Mm-hmm. So there's basically two interactions. There's the first one with Trooper Medina at the greeter post, but you can only see it from Medina's perspective. You can see the red light in the car paint, so that you can clearly see the lights on there. Mm-hmm. And then when the defendant is directed into the pit, you can clearly, you can see Trooper Clark in Trooper Cantwell's video and vice versa. And from both points of view, you could clearly see the red light is on. So there was testimony. The judge, for whatever reason, didn't make any, he didn't even refer to that testimony, but there was testimony about that. The troopers were not discredited. He just says, I don't find evidence that, or he just writes, there was no evidence that the operation of the camera would place people on those. We respectfully disagree with that. I mean, I would say that the video.
Finding of law or fact?
I think that I would say that it's a finding of fact, but also with respect, at least to what's in the video, you can de novo review that anyway.
So you think it's clearly erroneous?
Yes.
Because we have the video.
Right. Also, he just ignored the testimony of the trooper without discrediting it.
He found them credible.
Yes, he found them credible. He said that in the hearing, he didn't actually make any credibility determinations in the motion decision. And also he didn't have a preface that says, what's recited here is the only facts that I found credible. There's nothing like that. So there's no question about the credibility of the troopers here.
So wait, I'm sorry, what's your point there?
There was a sign.
What was the troopers say that would lead us to believe that the defendant had actual knowledge of the recording?
The sign and the lights on the cameras.
So but that's just an inference based on the signage and the red light on the camera. A reasonable person would know that they're being recorded, and therefore the defendant did?
Well, I think Jackson contemplates this because in Jackson, when the court's discussing secrecy, the court says, we don't actually need the defendant to just come out and say, yes, I know that I'm being recorded. It can be inferential. It can be inferential. And I would just say that the evidence here permits that inference.
The facts and circumstances show the defendant's state of mind, correct?
Right. It's inferential. Yes, it's circumstantial. Yes, exactly. And given that he drove past the sign and was looking at the troopers who had cameras on, he knew that it could reasonably be inferred that he knew. There was an affidavit from the defendant that said that he didn't know, but that wasn't really that was not evidence at the hearing. It was a Rule 13 affidavit.
But the judge seemed to draw the contrary inference from the videos based on where the judge saw or thought that the defendant was looking at various points, and where the judge's findings rest on her review of the video, and she makes a finding of no actual knowledge. How can the inferences that you're asking us to draw lead us to conclude that the judge's findings were clearly erroneous? Or are you arguing we should just review the video de novo ourselves?
You should review the video de novo. Also, it was a male judge, but I'll just...
Oh, sorry.
In any event, I think you could just... I mean, there's a red light visible on these cameras. They're small black rectangles. In the video, you can see the lenses on the cameras. You can see the red lights. The video clearly shows that these objects are cameras.
You are not contending that one can draw any conclusions about the sign from the videos, correct?
No, you can't see the front of the sign from the video. That's true, because where Trooper Medina was posted, he was behind the sign. And in fact,
You can see a sign in the Medina video.
you can see the back of the sign.
You can see the back of a sign,
Right.
and you can also see that there's a large truck parked, sort of, there's the sign, the Medina's here, the sign is here, there's a large truck parked that would have meant that a driver approaching the sign would not have seen the sign as soon as the driver might otherwise have, because the truck is there. There was testimony about the placement of the sign, and the testimony was that the sign was on the other side, that it was on the left side as the driver approached, but that sign that you can see in the video was on the right side. Do you think that testimony is mistaken about where the sign was? And it seems like you're saying the testimony was mistaken, and then the sign is that sign that you can see on the video. Is that your interpretation?
I believe that the sign, yes, maybe they got right and left confused based upon perspective, because in the video, it's on the left.
Yeah.
Yeah.
Correct. And I mean, the question was posed to the trooper very specifically about, as the driver approaches, was it on the driver's left or driver's right? And the officer did say on the driver's left, but that could have been confusion. I think it's clear that, as the judge found, there was not very clear testimony about where the sign was. But your position is that sign that's trying sort of a sideways, sort of diamond is the sign.
I believe that's what happened. I think that's that. I don't see any other sign on the video. But again, the fact finding is that there is in fact a sign that warns of recording. So regardless of any of this other stuff, there is a sign in the judge's fact findings. There's also.
Can I ask you about the is willfulness at play in this appeal? Was that something that the Commonwealth pressed at the motion? There didn't seem to be explicit findings by the judge on that, but I just wonder if at the beginning, as a threshold matter, is that something we even should be considering, and whether or not that's waived?
Well, I don't think that the memo below focused on willfulness. Part of the willfulness discussion is in response to the judge thinking that it's important that the police did not follow their body-worn camera policies. I'd also note that, I mean, the defense is not arguing, the defense has not made a waiver argument as to this point, but so it's not squarely in the memo, but I think that it's raised on the, at least in the way that the judge decided the motion, I think it's barely huge.
You think it's still a live issue?
I would say so.
Mm-hmm.
And again, the existence of a sign also shows that it's willful, or that it's, I'm sorry, the fact that there's a sign also shows this is not a willful interception.
Well, it's a willful modifies interception, correct?
Right.
Of course it's a willful interception because they were told by the policy they have to record these things.
Well, I mean, they don't mean for it to be secret. That's what I mean.
Right. But
Right.
Willfully intercept means it wasn't done by accident. They purposely recorded because they have to.
Right. Well, yes, they do have to, but they certainly don't mean for it to be a secret.
So is it the Commonwealth's position, or was it even argued below, that willfulness modifies the secrecy of the recording and not just the recording?
This was not briefed below, so I'll just admit that.
Thank you.
The amicus announcement discussed the significance of whether the police didn't follow their body-worn camera policies. I would submit that the statute is silent about body-worn camera policies. It doesn't contemplate the existence of body-worn camera policies. So I would say that simply because the police have not followed a policy does not mean that ipso facto there's a wiretap statute violation. If that's what the legislature intended, that would be in the statute.
But clearly it's a factor.
It could be, but I would say that, I mean, the policy is 12 pages long, and there's a variety of different rules that the police are supposed to follow in the policy. The whole policy was in evidence. And what the defense is focused on is that they didn't orally tell the defendant that they were recording. I would note that in Jackson, the court actually says you don't actually have to tell someone that you're being recorded in order to avoid an interception. So the statute's already been interpreted to say you don't have to tell people that you're recording them in order.
Well, in Jackson, the facts were really different because the person who was being recorded said on the phone, "I know you're recording."
That's true.
And there's no evidence like that here.
That's true. But at the same time, that's just a general statement about how the statute works. There's nothing in the statute that says you have to tell people that you're being recorded in order to avoid committing an interception. Now, informing people that you're recording is a way to avoid violating the statute. For example, I mean, the court has signs on the exterior of the courtroom that says you're being, I've been informed based on those signs that I'm being recorded right now. I know that I'm on YouTube. You don't have to have a sign necessarily. The statute doesn't say anything about that. And likewise, the statute says nothing about following body-worn camera policies. I'd also note that what the judge actually found was that some troopers failed to turn on their cameras when they were interacting with members of the public. He didn't actually find that the police didn't follow the part of the policy that requires them to tell people that they're being recorded. So the actual violation of a policy that the judge found, I don't understand how that constitutes a body-worn camera. I'm sorry, I don't see how that violates the wiretap statute. Other troopers supposedly didn't make recordings. That doesn't violate the wiretap statute. Unless there's anything else, I'd rest on my brief and ask that you reverse.
Thank you.
Thank you.
Attorney D'Souza.
Good morning, Your Honors, and may it please the Court. Kyle D'Souza for Mr. Scott Grimaldi. Fundamental to our position is that non-compliance with departmental policy is evidence of willfulness to secretly intercept. So non-compliance with departmental policy speaks to willfulness. And here we have significant evidence of willfulness. First, you have Trooper Medina standing in the roadway. Medina sees Mr. Grimaldi approaching the OUI checkpoint at a high rate of speed. He sees the large semi-truck trailer blocking the sign that the Commonwealth alleges would have put Mr. Grimaldi on notice. Those two observations lead Medina to conclude that Mr. Grimaldi obviously doesn't pay attention to signs. He communicated that over the radio to his fellow officers. After that initial interaction, Grimaldi is brought into the OUI checkpoint, the pit. Once he's in the pit, Troopers Cantwell and Clark approach him. Trooper Clark is Trooper Cantwell's field training officer during this interaction. His purpose on that evening, he testified to this, was to train her, stay with her throughout the entire
Where are you
interaction.
getting willfully, secretly intercept from?
What was that?
Where are you getting willfully, secretly intercept?
Well,
you jumble the words together.
so
Why are you doing that?
The statute says it is a violation to commit a willful interception.
Okay.
So an interception is a secret recording using an intercepting device. So
It's in violation to willfully intercept. Willfully modifies intercept, correct?
correct,
Okay.
correct,
It's only interception if it's secretly,
Correct.
not done out in the open.
Correct.
They're two different concepts, as we've said, not case law.
correct,
Not jumbled together, right?
correct.
Okay.
So we have significant evidence of willfulness. Trooper Clark, Trooper Cantwell's field training officer,
Of course it's willful. They have to record.
correct. So
All right, so now we have to get to secret.
Secrecy.
All
Perfect.
right, let me ask you something.
Yep,
In Jackson, we talked about actual knowledge, but our case law has left open, and it shows, it looks at the intercepted party. What did that person do? What's evidence about him? But our case law in Hyde and in the Joe Call case, Boyarsky, we say that it's not secret if it's known, if it's out in the open. We can do that by an announcement. You can do that by holding a device out in the open, like a recording device, correct?
so I would say Hyde is a bit of an outlier because in that portion of Hyde that says that, it would have been avoided had he held the tape recorder in plain view, it directly cites Jackson, and it says that there is no interception where the party is aware that they're being recorded.
And the First Circuit has said that Hyde clarified Jackson, correct?
Correct.
You don't think that's true?
I think it could be true, but I think that the circumstances of this case are unique relative to what Hyde was contemplating.
Boyarsky comes after Jackson, and Boyarsky says, of course, because they gave an announcement, it's not secret.
Correct.
It has nothing to do with the conduct of the defendant, correct?
I would argue that Jackson establishes that we need to show actual knowledge, proved where there are clear and objective manifestations of knowledge on the part of the defendant. Our objective is to...
So if they had, suppose the facts are a little different. Your guy pulls up and there's a neon sign that's as big as this courtroom wall and says, "You are being recorded." Is that sufficient?
I would say that plays more to cases like Rivera, where you walk into a convenience store or you walk into a bank and automatically it is reasonable to infer that you're being
The
recorded.
neon sign hypothetical.
Yep,
That's an objective fact, has nothing to do with the subjective knowledge of the defendant. It's an objective fact that shows an inference of knowledge, correct?
correct. I would say
Right,
that...
so if the cops in this case had a 1990s style camcorder and they held it up like that when I filmed my kids when they were 1, all right, is that objective facts?
I would say that the case law would allow that. The way the case law has been interpreted.
Would that be a wiretap violation if they use a 1990s camcorder?
No, because that camcorder does not present the same problems as the body-worn camera. The body-worn camera is a new piece of technology. It is a piece of police technology. It is evolving technology. And I think it would be fundamentally unfair, unlike the recording camera, it would be fundamentally unfair to expect members of the public to automatically know that that device is capable of making audiovisual.
So this case really turns on whether or not that device that has a lens and a red light, we can have an inference that the defendant knew he's being recorded based upon our review of what a person would believe seeing that device worn by the cop, correct?
Correct. But I would make a couple factual points about the red light and about the camera. First of all, it is a small device. It is a small square device. There are 2 red lights illuminated at once, and the red light that is immediately on the front of the camera is elongated. So I'm not sure that we could immediately draw the inference that that device is recording and audiovisually recording specifically. So I think it's perfectly reasonable for somebody to infer that 2 red lights means no recording, right? Or how could a member of the public possibly know, right, whether 1 red light meant recording, 2 red lights meant not recording? I think it's unfair to put that burden on the public rather than having the police just follow their policy and notify that, or, you know, make that notification that they're recording.
I hear you. I don't want to misstate your argument, so I want to make sure I understand your argument as I've just heard it. The first piece is that you would acknowledge that an outward manifestation of understanding is not necessary in all cases, because if there is sufficient notice of a type that, and I guess this would be a question of law, that would put anyone in the defendant's shoes on notice that he or she was being recorded, that would be sufficient to determine knowledge on the part of the defendant, even in the absence of an outward manifestation of knowledge.
Yes, we would agree with that. And I think, like I've said before, there may be cases when it is so open and obvious to a member of the public that they're being recorded, right? Like you walk into a bank, everybody knows when you walk into a bank, you're being recorded, right? In those situations.
So does the case boil down, and I guess I'm just rephrasing or restating even Justice Gaziano's question, as you see this case, it would boil down to our determining whether, as a matter of law, the body cam, on reviewing the videos, how the body cameras were displayed, the lights, general public knowledge of body camera usage by the police, et cetera, whether that was enough.
I would say that those are all factors that the court should consider in coming to the decision. I would also just like to warn of some of the dangers that come with the Commonwealth's argument. It would require us to assume and place that assumption on members of the public that they automatically are apprised of how police technology is evolving. I could see 5 years from now, we could end up in a situation where instead of body cams, we have Google glasses, some other device that's capable of recording. And how would we handle that in such a situation? How could we automatically assume that members of the public knew that these new devices are capable of recording? I think it's dangerous.
Can I go back to the question about willfulness? So obviously, to be an unlawful interception for the grounds that this defendant has moved to suppress, you agree it has to be willful.
Correct.
And it seems like you actually were conceding that because it has to be a willful interception, and interceptions are only secret recordings, it has to be willfully secret. You have conceded that.
Correct.
So how can we find a willful secret recording where they literally set up this whole, I think the judge found that he couldn't find that the defendant saw the sign, but they set up this whole OUI checkpoint and they put up a big sign that multiple officers who were credited testified said visual and audio recording. How could you find that the officers willfully, and then they're wearing them openly, and at one point the officer takes it off and is pointing it at the defendants? How can you say that that's willfully secret on the part of the police?
Because I think all of those factors actually play in favor of willfulness. The officers knew that he didn't see the sign. They knew.
No. Sorry, go ahead.
Oh, sorry. Trooper Medina calls out over the radio that Mr. Grimaldi obviously doesn't pay attention.
Yeah, because he didn't stop.
Correct. Well, and he was also impaired, and they understood that he was vulnerable and in a position where it was harder for him to understand the circumstances of the encounter. And I would say that in terms of taking the camera off and holding it, there was testimony that that decision was not to notify Mr. Grimaldi, it was to improve the angle with which they could record the interaction. So that was not a way to signify or notify that they were recording him. It was to increase their ability to gather evidence. It was to get a better angle of the video, of the field sobriety test.
But why does that matter if we're trying to determine whether your client had noticed that he's being, forget about why they're saying they're taking it off. From our kind of outward look, he's got a camera being held up to his face.
Well, I think we run into the problem of him not knowing that it's a camera, and they understand that he's impaired. They understand that he never looks at the camera, he never acknowledges the camera, he never asks about the camera, and they know he didn't see the sign. So in the minds of the officers,
So maybe they know that he didn't see the sign because of what Trooper Medina says, but they're not hiding the recording.
they may not be openly hiding the recording.
They're not hiding it at all.
But I think that they understand that Mr. Grimaldi did not know that he was being recorded.
But there's two requirements, right? There's the willfulness and the knowledge. So maybe he doesn't, the defendant doesn't know, but are the officers acting willfully when they're openly using the body-worn cameras?
I would say they're acting willfully because they're trying to take advantage of his lack of knowledge. They understand that he doesn't know. And I think that's where we tie in Ennis and Boyarsky. So Ennis and Boyarsky say that we can consider willfulness by looking at the knowledge and control of the intercepting party.
They're trying to take advantage of him when they have the camera. He takes it off.
He's holding it like right about here, but I would say that, like I said, he
But he's
testified.
not, I mean, it's not because he's trying to hide it. It's because he's trying to get a better view. Right?
I would say yes, for his own purposes. He wasn't doing it for Mr. Grimaldi's purposes.
No, but it doesn't matter if he was doing it for Mr. Grimaldi's purposes, if he's
Trying to get a drunk driver off the road.
Well, I think he understood that he was impaired, and he understood that he didn't know he was being recorded. So I would argue that all of those factors taken together, right, especially with Ennis and Boyarsky, where
He's trying to document the field sobriety tests, right?
yes, but he could have taken one extra step and just followed his departmental policy. Right? Our argument fundamentally is that they understood their obligation to record because that is step one of the policy. He's the field training officer in the process of training his subordinate with 1 month of experience. Despite knowing that, and despite knowing that Mr. Grimaldi is impaired, and despite knowing that Mr. Grimaldi never acknowledged the camera, they never move on to step two. And we argue that that is significant evidence of willfulness. He never notified. This is somebody who was...
Isn't there between best practices, and I hear you saying that they should have followed their policy and say it, right? But isn't there a difference between that and our what we have to figure out?
I would say yes, but I would say that it's greater than just a matter of best practices, because the very fact that they had all of these factors, they knew he was impaired, and they still didn't move on to that next step to notify him.
What is the policy?
So it's a long policy. It covers body
But
cam.
the part of the policy that you're saying was violated.
So that part would be the second prong, and it says, as soon as reasonably practical, as long as there's no emergency situation, they have to, at first opportunity, notify the person that they're being audiovisually recorded.
And so you're saying that the officers could not have relied on the signage?
Because they didn't know he saw, they specifically knew he didn't see the sign.
Well,
We-
sorry.
Go ahead.
If, hypothetically, if the officers had orally informed the defendant, you are being recorded, and he made no acknowledgement of that, would you concede that there would be no willful violation or willful interception here?
Yes.
So that seems to me an acknowledgement that in terms of determining whether something is willful, we're not really looking to the defendant's manifestations of anything.
Correct. That would be more towards the secrecy
Okay.
prong.
So, all right, that's helpful to me. Thanks.
Can I ask you something? You brought up a number of times the defendant's his intoxication. We have knowledge requirements in a lot of cases, a lot of the firearm cases, that guns loaded, extended magazine, etc. Are you aware of any case law that says that we should consider the defendant's sobriety when we assess facts and circumstances to show knowledge in mens rea?
Not off the top of my head, but
You're not going to find one.
I would say that his intoxication plays to willfulness, and that was kind of how we thought of it, because they understand that he is vulnerable, and they understand that there's a greater probability.
It has no bearing on knowledge, correct?
I would agree with that. Last point, I would just like to mention.
Sorry.
No problem.
Is it something that's in your brief?
The last.
Yeah, just tell us what your last point is, but
Okay. Last point was just statutory interpretation and legislative intent.
is that in your brief?
At the end of the brief. Last point. So the legislature's intent was to deter law enforcement from using intercepting devices to violate people's privacy rights. If we take the Commonwealth's position and we create a carve-out exempting body-worn camera from suppression, then we have directly undermined that deterrent purpose.
Well, counsel, the chief already gave me the high sign that I could ask you this question if you're going to bring it up. So I understand what you're saying, but the wiretap statute was enacted when they were putting bugs in lamps, right? And here we have a sobriety checkpoint where everybody's being routed through, where you've got all of these police officers and troopers sitting around with these things on their chests that have red lights that I think you want us to believe that not everybody knows that that means something. Isn't this far and away from what the legislature intended when they talked about the surreptitious surveillance that Section 99 was enacted to protect against?
I think it's every single case from Jackson to do reiterates the deterrent interest of the legislature. And I think that as we see here, it is very easy for these intercepting devices, these body-worn cameras, to become secret intercepting devices. People may not know that they could be speaking freely and have no idea they're being recorded. So I think that that plays into the deterrent purpose that the legislature was trying to establish.
Thank you. Thank you, Chief.
If there's no further questions, I'll rest on my brief.
Thank you.